Indemnity and guarantee. The general principles of contract are contained in sections 1 to 75 of the Indian Contract Act, 1872. The remaining sections of the Act, viz. Sections 124 to 238, deal with three specific kinds of contracts, namely 1. Indemnity and guarantee, ch. 8, Secs. 124 to 147, 2. Billment and pledge, ch. 9, Secs. 148 to 181. 3. Agency, chx, Secs. 180 to 238. It may be noted that Secs. 77 to 123 have been repealed and are now embodied in the Indian Sale of Goods Act, 1930. The remaining Secs. 239 to 266 have also been repealed and are now embodied in the Indian Partnership Act, 1932. Contracts of indemnity and guarantee are a species of the general contract. As such, the general principles of the law of contract are applicable to them. The special principles relating to them are contained in Secs. 124 to 147, Contract Act. Contract of Indemnity Superscript 1. Indemnity is a security against, or compensation for loss, etc. 2. Indemnify means to make good the loss of another in certain events. 1. Define the term indemnity. What are the essentials of an indemnity contract? As per Section 124, Contract Act, a contract by which one party promises to save the other from loss caused to him by the conduct of the promiser himself or by conduct of any other person, is called a contract of indemnity. Illust. A contracts to indemnify be against the consequences of any proceedings which C may take against B in respect of a certain sum of 200 rupees. This is a contract of indemnity. The person who gives the indemnity is called the indemnifier, and the person for whose protection it is given is called the indemnity holder or indemnified. An example: A sends a parcel of books to his friend B through railways. A sends the railway receipt by post which entitles B to claim the parcel from the railways. If the receipt is lost, B can claim the parcel from the railways by filling in an indemnity bond by which he undertakes to make good the loss of the railway in case any other claimant comes forward to claim the parcel. A contract of indemnity is an original and direct engagement between two parties. It is really a kind of contingent contract. The promisee under a contract of indemnity must have suffered loss before he can hold the promiser liable. The happening of the loss is the contingency on which the liability of the indemnifier springs into existence. The general principles of the law of contract are also applicable to a contract of indemnity. Thus, the consideration or object of an indemnity contract must be lawful. For example, an agreement to indemnify the printer-publisher of a libel by the writer of the same cannot be enforced. Likewise, an agreement by an accused or any other person to indemnify the person who has given bail is illegal. Q.1 Discuss whether an insurance contract is a contract of indemnity. A.1 Insurance contract, if contract of indemnity. The definition of a contract of indemnity, as per Section 124, Contract Act, covers indemnity for loss caused by human agency only, a promise to save another person from loss which may be caused by the conduct of the promiser himself or by the conduct of any other person. It does not include loss caused by natural factors, not involving human conduct, like accidental fire, perils of the sea, etc. That is why insurance contracts are not covered by the said definition. Thus, if under a contract of insurance, an insurer promises to pay compensation in the event of loss by fire, such a contract does not come within the purview of Sec. 124. Such contracts are, however, valid contracts, as being contingent contracts defined in Sec. 31, Contract Act. But, in English law, the loss might be caused by a human agency or by other natural factors also. The English definition is, thus, wider than the Indian definition. Life insurance contract is, however, not a contract of indemnity under English law also. In such a contract, different considerations apply. Such a contract may provide the payment of a certain sum either on the death of a person or on the expiry of a stipulated period of time, even if the assured is still alive. In such a case, the question of amount of loss suffered by the assured, or indemnity for the same, does not arise. Moreover, even if a certain sum is payable in the event of death, since, unlike property, the life of a person cannot be valued, the whole of the amount assured becomes payable. For that reason also, it is not a contract of indemnity.